Hello, everybody. Welcome to our webinar today, which is Navigating China, Business and IP Best Practices. The speakers for today are Mr. Bernando Mendia, Secretary General of the Portugal-China Chamber of Commerce and Industry, Mr. Mário Ferreira, Director of South China for AICEP Portugal Global, and we also have two key experts, Mr. Feng, our China IP expert for today, and Mr. Petino, Business Advisor at the EU SME Centre. I'm Giacomo Pozzi, Project Executive at the China IP SME Helpdesk, which in a nutshell is a EU project that has the goal to give a free initial advice to European small-medium enterprises and small-medium enterprises from the Single Market Program about intellectual property in China. We cover 4 different jurisdictions, mainland China, of course, Hong Kong, Macau, and Taiwan. And so far, we have assisted more than 100,000 small-medium enterprises. Our main service is the helpline, so it's free, fast, and confidential. You can drop us an email with all your IP-related questions, and we will give you a proper advice in 3 working days. So I really encourage you to send us all your questions about IP. Besides this service, we also have, we organize training workshops and webinars, such as the one of today. We also have a one-on-one consultation session service. Basically, you can book a one-on-one consultation of 30 minutes with our in-house business advisor. On top of it, we also have self-learning materials on our website, which is everything is free of charge, of course. You can download it, and you can have a proper information about intellectual property in China. So I really encourage you to visit us. Here are some examples of the material that is published on our website. We cover different industries, but also we have fact sheets and guides that are more general for companies, entrepreneurs that don't have the knowledge yet about IP in China. Also, we have at the European level, we are part of a bigger family of help desks that cover the whole world, I would say. So we have Latin America IP SME Helpdesk, one for Africa, one for India, Southeast Asia, and of course the European IP Helpdesk. So here are our contacts if you want to stay in touch and be updated about all the activities, such as today's webinar. I really encourage you to follow us on LinkedIn and also to watch our previous webinars and trainings on YouTube. For example, this webinar will be registered, and yeah, it will be on YouTube soon. So thank you very much. And I will leave the floor now to Mr. Bernando Mendia, Secretary General at the Portugal-China Chamber of Commerce and Industry.
Thank you very much, Giacomo. It is a pleasure to be here and an honor also to be invited to co-organize this webinar. This is part of the role of the Portugal-China Chamber of Commerce and Industry, which is to provide quality information. And I believe today this will be achieved because we have with us an expert on intellectual property, Mr. Charles Feng, who has been coming to Europe for the last 10 years. We also, besides the IP We also have our colleagues Alessio Petino and Davide Orlandi, who will introduce. And just like me, Mr. Mário Ferreira, my good friend from the Portuguese Investment Agency, who will also introduce the agency. As to Portugal-China Chamber of Commerce and Industry, we are a business association between Portugal and China, which was established in 1978. So this year we celebrate 45 years since the foundation, and our role is to connect Portugal and China to established bridges, and of course to promote the economic and the commercial relationship. So this type of webinar with the quality of these speakers, particularly Mr. Charles Feng from the IP sector, will be very useful for the SMEs, which are indeed the backbone of the European companies and the ones that need this type of help. So Giacomo, congratulations for also putting this on the YouTube, because it's very important that the companies can consult this at any time. And that's it from me. I pass the floor to Mr. Mário Ferreira from AICEP.
Yeah, please, Mario, if you want to, you're muted. You're muted. Okay.
Oh, now I can't. Well,
oh yeah. We can hear.
Hi everyone. Thanks for your nice words, my good friend Bernardo. Yes, as Bernardo said, I represent AICEP Portugal Global. So we are a governmental body focused on development of competitiveness business environment between Portugal and the other markets. Specifically here in China, we are present in 4 different geographies. We are in our embassy in Beijing. We are in our consulate in Shanghai, Macau, and here in south of China in Guangzhou, where I am. So basically, we are a tool for the Ministry of Foreign Affairs from Portugal to support the globalization of the Portuguese economy. We are a trade and investment agency, so we work on 2 fields, promote the Portuguese products and services in overseas markets, and attract overseas investment from Portugal. Here specifically, we are in China, so one of my main mission is to attract Chinese investment to Portugal. As an agency, we are free of charge. We promote, as Bernardo said, we try to promote is one of our pillars, to promote good information, to connect the Portuguese companies with different entities in their different markets. For example, here in China, to connect them with the EU SME Centre, because it's an important partner to support us, as I mean Portuguese economy, to have more support locally. Special, this webinar is a very important topic, not only for Portugal, but for most of the European companies, the IP issue, and is very, it's totally important to be aware of this information in advance to move to this market. It's possible. Of course, Chinese market is a complex market, but that's why it's a very important market to us. So we need to look at carefully, but it's possible. And it's possible with our support, with the Chamber of Commerce supports, and of course with the IP SME Centre. So I don't have any further information. Maybe we will have some time in the end for some Q&As, and I'm totally available to answer and to support you. I don't know if there's any Portuguese company assisting us, but I'm here. Thank you so much for this opportunity.
Okay, great. Thank you very much. So we have now Alessio Petino and Davide Orlandi from the EU SME Centre. So Davide works for the EU SME Centre in Europe, and while Alessio lived a lot of years in China, and also I will give the floor now to Davide to introduce the services of the EU SME Centre.
Thank you very much, Giacomo. First of all, thank you very much for organizing this event. Thank you very much to the CCILC, to AICEP. I believe this is indeed a fundamental topic to assess today, and I'm glad we have the chance to discuss this. So without further ado, I would like to briefly present EU SME Centre. This is an EU-funded initiative that has been ongoing ever since 2010. As you can see, this is already the 13th year of life of the project. Consequently, it has been deemed fundamental that the SMEs can have support from an entity such as the EU SME Centre. As I was mentioning, the overall idea is that of providing a general support, a general introduction to the Chinese market, and being able to identify potential issues that the enterprises might face, and being there in order to solve them and prevent them as well. As you can see, at the bottom of this slide, the project is implemented by 6 partners, 4 consortium partners and 2 associated partners, both representing both based in Europe as well as in China. In China, we have the Italian Chamber of Commerce as well as the European Chamber of Commerce. In Italy, we have the Italian Council Foundation. In Portugal, we have SPI. And then we have 2 associated partners, both based in Brussels, Trade Promotion Europe and the EU-China Business Association. As I mentioned, the overall goal is that of supporting the enterprises that want to enter, accessing the Chinese market, or that want to expand in the Chinese market. In order to achieve this goal, mainly 5 services, 5 instruments have been created. The first 3 can be taught as kind of a ladder, directly accessible by the enterprise through EU SME Centre website. I would like to briefly remember that all of these services are free of charge for all of the EU-based enterprises and countries participating to the Single Market Programme. So the first instrument is the self-diagnosis tool. The enterprise can directly access this quiz and check if they have all the background knowledge necessary for approaching the Chinese market. Should that not be the case, the self-diagnosis tool directly prompts the enterprise to check some of the documents that have been published by EU SME Centre in the previous years. As I mentioned, the project has been ongoing for 13 years, so there is a relevant database that is accessible. And this prompts me to point out that the second component, the second service, is this knowledge center, which comprises all of the 250 plus documents, market reports, guidelines that we've published in the past years. Of course, these documents are all kept up to date. Should that not be sufficient, there's also the possibility to directly ask questions to our experts through the Ask the Expert function. Here we have the possibility for the enterprise to directly pose questions that are relevant for them in their specific cases, their specific issues, and our experts will reply to them hopefully within 24 hours or very soon anyway. The last 2 services offered are the training service, such as that includes webinars such as the one that we're conducting today, as well as in-person training activities. And the last service is the advocacy one, mainly focused for those enterprises that are already present in the Chinese market, and that focuses on collecting issues that this enterprise might face in order to later bring them up at the governmental level. I've tried to be as short as possible, so I would like, first of all, to thank you all for your attention. If you would like to learn more about the project, please reach out to me at davide.orlandi@eusmecenter.org.cn. You can find the email in this slide. And I'm definitely looking forward to the following presentations, and I'm giving back the floor to you, Giacomo. Thank you very much for having us here today.
Thank you very much, Davide. And now I invite Mr. Alessio Petino, business advisor at the EU SME Centre, to explain a little bit more about which are the best practices for doing business in China.
Thank you, Giacomo. Good morning, everybody. Thanks for the help desk, to our Portuguese partners for organizing this. I'll try not to be too long today, as the focus is on best practices, especially from the IP side. Sorry. Yeah, what I'll do, I will also introduce a few good practices from let's say the general business perspective rather than the specific IP angle. But of course, sometimes these are a bit intertwined. So maybe first a brief introduction about the current situation, what we're seeing as EU SME Centre, what was the our take. So I would like to start a few years back during the pandemic. There was, despite all the narrative that we read on media and everything, we have always seen strong interest from European companies for the Chinese market. Of course, during the pandemic was a bit challenging to do anything, to achieve anything tangible for objective difficulties, but the interest was there. And now, since the lifting of these restrictions this year, of course, business contacts have resumed. We have also seen some measures and new regulations in attracting foreign investment or also people. I think last month there was this announcement of visa exemption for a few countries, probably will be extended to other countries in the future, but it's certainly a positive news. So there have been some efforts to try to, let's say, to this charm offensive to try to lure back foreign companies which had suffered during the pandemic. So our take on this, to summarize, let's say, these measures or this development, our take is that in first-tier cities, Beijing, Shanghai, Guangzhou, our impression is that the type of foreign investment that is welcome is more like a kind of what I define high quality, meaning like for investment in priority sector, in strategic sectors, or with pretty high-tech products, or like bringing manufacturing in China or R&D operation in China. This is what I refer high quality. While maybe non-high quality, let's say, for investment, I think there are more opportunities in lower tier cities in contrast to first tier cities. Direction, there's been a very intense regulatory activity in all sectors, which is not necessarily negative, of course. It's also positive, but this means that there are more costs for compliance. You have to adopt some measures to be compliant, to demonstrate compliance. Sometimes you need to get some certifications. Sometimes you need to demonstrate compliance. So this brings extra costs, and in any sectors. In practice, China is incredibly challenging, and in order to be successful, you really need a strong business case. It's not like 20 years ago where there were more opportunities. Now you really need to think very well about what you're bringing to China. And you also have to remember that China has had a very strong industrial policy, which also has some advantages. You kind of there's a lot of planning. You kind of anticipate what are the needs, what are the directions that the country wants to develop. So if you study these documents, then maybe you can try to anticipate where more opportunities will be. When SMEs go to China, we see a lot of challenges that they encounter. I think the most fundamental one is the lack of sufficient knowledge, preparation, and commitment. I will provide more details on this point in the next slide. Working with wrong partners, sometimes, because they want to rush to get into China, so they decide to reach a deal with the first or the second partner they meet, but sometimes these are not necessarily the best ones. Sometimes you enter in a relationship, in an exclusive licensing relationship, which might cause troubles on the long term. In case your partner underperforms, it might be difficult to get out of this partnership. So this is an issue. A different role of government in business. I think government is much more present compared to Europe for also for the good. I mean, they're also especially at the local level, at the district level, local administrations are very ready to support your operations through various means. Also by introducing other contacts, possible clients. So there is something that we have to get used. When we go to China, you never know who you're dealing with. Another challenge is China is incredibly expensive, and there are a lot of unwritten barriers. So what you see on paper, on the law, is not necessarily what you encounter in practice. Maybe you might encounter a few more, let's say, unwritten requirements which you have to deal with. Cultural factors, of course, not only in terms of intercultural communication, but also in terms of corporate culture. You have to be. So these are some of the most frequent challenges that we hear from European SMEs that go to China. I have 3 or 4 type tips for you. Of course, these are pretty general. We can elaborate in more detail during the Q&A. I think the first issue is that entering China is a very, well, any market, of course, but especially China, I would say, is very difficult. You have to be very careful about how to enter it. First of all, if you can enter it, because it's not certain that your product is allowed to be sold in China. But if it is, then also how, when, where. There are different market ways to enter. There are different ways to enter the market. There is general trade, cross-border e-commerce. You can do both. You can do one first and then the other. So each has different advantages. You can export directly. You can produce in China. You can outsource. You can work with OEMs. You can also work with distributors to sell your product. You can do your own sales. You can do both in different regions. So there are different ways. There is no right or wrong. It all depends on many factors. You might also need to adjust your product, to change your product. We mentioned that sometimes products need to abide. Some products, some ingredients might not be allowed, especially in the F&B, food and beverage sector. Some products considered high risk might not need a certain protocol at the government level, and if there is no such protocol, you simply cannot export it. There are some standards. There are standards, some of which are mandatory, while the majority are recommended. My takeaway is that you should always know what are the recommended ones, because even if they are only recommended but not mandatory, in practice they could become mandatory in some cases, especially when it could be an unwritten requirement, an informal requirement of your importer. Let's say that if they want to be praised by the local administration, or maybe go through public procurement, they will get extra points if they meet recommended standards. So you should always know what is mandatory, but also what is recommended. Technical standards, China has its own standards. Fulfilling with ISO standards, European standards is not sufficient to have your product sold in China. Around 85% of Chinese standards are aligned with international standards, but the remaining 15%, which is a pretty significant proportion, are not. So there might be differences, and this implies that your product might need to be changed. Many products, especially in food and beverage, cosmetics, health food, medical devices, they require some pre-registration. They must be registered with the competent authority before they can be sold in China. Process might take even a couple of years and a lot of costs. So you should be very familiar with these requirements. And yeah, I'll skip this. And most importantly, you will need solid financial resources to sustain operations initially. You cannot expect to generate substantial revenue at the beginning. You are basically a startup when you enter China, even if you're pretty solid abroad. Another thing about meeting importers, many companies come to us asking how can they meet potential Chinese importers. Well, I think if you don't have any contact on the ground, if you don't have any operation on the ground, I don't think you have many other options than trade fairs. Trade fairs, of course, there are many trade fairs in China. The problem with trade fairs is that not all of them might be useful. You have to be very careful in which one you're attending. Some trade fairs might have more business visitors. Some trade fairs might have more curious people going there to taste products. So depending what's your objective of trade fairs, if you want to do marketing, if you want to meet importers, then you should carefully select the trade fair. You need to be very prepared. For instance, I mentioned that some products require to be registered with the competent authority before they can be sold. You have to know this before you consider going to a trade fair, because if you go to a trade fair and you don't know that milk, for instance, or meat require 1 year to be registered, no Chinese importers will talk seriously to you. So it's completely a waste of money. So you will have to be aware of it at least, or even better, have completed it. These registration procedures. And of course, trade fairs are pretty expensive. Another way is that if you already export to international market, sometimes it could work that maybe with your existing client, if they have China operations, then maybe if I have a subsidiary in China, maybe you can try to see if the same solution would work within the same company, but the China subsidiary. Sometimes it could work. Local chambers of commerce, embassies, some European chambers and embassies might have some contacts, might have some lists. So of course, it's always a great idea to get in touch with them, including AICEP and the other Portuguese Chinese chamber. So it's always, I would say, the first thing to do. Alibaba is a B2B store, not AliExpress, but Alibaba is a B2B one. You can actually sell to China. You can sell to all countries on the world, but you can see who, even if you don't sell, you can just identify some potential importers and distributors there. I mentioned these trade fairs. You have to be aware of the requirements, and this comes from experience. We heard there was, in this case, this Polish company. They do milk. They went to this trade fair, but they didn't know that registering the product was so difficult. So basically, they spent a lot of money to go there, and no Chinese importers would seriously talk to them. They would say, okay, first complete the registration, then we're talking. Pet food, again, there was this company that had a 3% lamb in this product. Now, lamb at that time couldn't be imported from that country because there was no protocol. So the company basically had to change the recipe of the product. But of course, no Chinese importer would seriously consider this company because product as it was impossible to be sold. And many other cases, honey, but also games. Actually, we had a recent case of an online gaming company. There are very strict requirements for games, and they had to change basically the game in order to be published in China. If you have other examples, of course, write in the chat. I would say that there is kind of informal rule of thumb. I think to enter China, to be successful in China, to bring products into China, take the time, the resources that you would need in other countries and multiply by 2 or 3. Then that's the time and cost that are required for China. So it's a very gradual and long approach. You are a startup, you have to build everything from scratch, unless of course you are I don't know, big company. But if you are a small or medium company, you are a startup in China. Focus on one city initially. Don't go all in, take all China. It's just not possible. You will not be able to anyway. So just focus on one city, one province, and then maybe build from that later. It's fine to make mistakes. Of course, are different kind of mistakes, but in general, it's everybody does mistakes, so don't worry. And something very that I always like to say is that sometimes we hear European companies coming with this presumption that the products are made in Europe, they are pretty good quality, they are super high quality, they're safe. Yes, they are, but in my opinion, based on what I see, these features are not alone are not sufficient to sell your product. You also need a lot of marketing, you need a lot of branding, and of course this doesn't mean that all the products from other countries are not good enough. You are competing in China, you're competing with products from Japan, from United States, from Korea, from many countries. So it's not only European products are good. So sometimes I think this is common sense, but we still hear some kind of sense of superiority of many European countries. Again, branding and marketing are especially important. And if I can make a concrete example, wine. We have recently released a report on wine. Now, wine is a product that if you talk to wine producers in Europe, if they have to hire, let's say, to work with a professional in China, they would choose a market professional. They wouldn't choose a wine expert, because in China, the competition in wine is entirely based on marketing. Of course, also the quality, but first on marketing, and then on the product. So government affairs, well, if you operate in the industrial sector, I always suggest that somebody follow some government affairs activities, because as I mentioned earlier, government can be very proactive and helpful in assisting you. Last, yeah, maybe I don't have time for this, but we have a lot of case studies on our website, including we have released many case studies recently, so you can take a look. And the last point I want to mention is due diligence. You always need to know who your partner is. Sometimes it may be challenging in China because the structures behind companies might not always be entirely clear, a bit opaque, but you should try to do due diligence. The best way is to work with a law firm. Another way, which you can also ask us, we would be happy to do some background checks on Chinese companies, informal background checks. So we hear every week cases of disputes between European companies and Chinese partners, especially when the European company buys from the Chinese partner, from a Chinese supplier. Yeah, what you have to do, also if you want to enter an exclusive licensing partnership, you should know as much as possible about your partnership, and you should have a solid contract in place which safeguards you in case something goes wrong. You should check the business scope. If the company has some previous disputes, there are some databases to check this, and also the financials. Might be more challenging if it's a small company not listed, but you should always check this information. The business scope is very important, because sometimes what we hear very frequently is a company buying raw materials from China, but the seller, the Chinese seller, is only a trading company, so it's not the real manufacturer. And so basically you're buying products from a company which were produced by another company that you don't know. If you see in the business scope that the company is not allowed to manufacture products, then maybe you should know that products are manufactured by somebody that you should know actually. And this you have solid contracts in place, and this is very important. I'm running out of time, but I would like just to show this. Sometimes European companies come to us, say, hey, I've signed this purchase order with this Chinese company, or they send me this invoice, and the stamp on these invoices look pretty much like this. Now, if you see any stamp like this, these are absolutely wrong. You should walk away from anyone that uses this stamp, because these have zero value in China. Stamps with legal value look like this. There might be some differences sometimes. There might be some minor differences, but in general, they always look like this. So if you see this, is right. If you see the other ones, walk away. Yeah. Yeah, we have reports and guidelines that provide you practical steps. And very quick, last 1 minute more. China is changing significantly, and the changes in China happen at very short notice and a very drastic scale, I would say. Despite what we read online, I think for companies at the business level, at the operational level, China remains very important. It's not easy to, there are opportunities, there are many opportunities. It's very difficult to get these opportunities, but it's possible to get these opportunities. But at the same time, China remains a very important base for actually exporting to other markets. There are many European companies that export from China to Southeast Asia, to Korea. China has an excellent infrastructure, so it's a good way to do so. And there are also many innovations, many ideas now that are born in China. So being in China actually allows you to be very close to new trends, new innovation, which could actually be exported to other countries. You should be very informed and very prepared. China is not a side project. You have to be 100% into it. You need to be very aware why Chinese clients need to buy your product. And again, you should have safeguards. Yeah, if you have any questions, please reach out and or we can elaborate during the Q&A. Thank you, and sorry that it was a bit longer.
No, no worries. The presentation was great. Thank you very much, Alessio. So now, before giving the floor to our IP expert, I wanted to run a little quiz. So I actually invite everybody, like a quiz on intellectual property. We actually make it to assess our activities and to understand how much companies know about intellectual property. So this is going to be 2 minutes long before Mr. Feng's speech. And then after the speech, or the presentation of Mr. Feng, we will see how much have you learned, let's say, during the presentation. So that's a little test for you. Let me share my screen. Okay. So I invite everybody, as you can see here, to use the code that you see here on the yeah. So I'm gonna wait. You can both put the code that you see here, or you can actually scan the QR code and go to menti.com. I just sent you the website in the chat. So I can see that somebody is answering here. So the first question is, when does the trademark protection take effect in China? When you start using the trademark after the application has been submitted, or once the trademark is registered in China. I won't give you the right answer now. We will do it after the presentation of Mr. Feng. So let's wait a couple of seconds if somebody hasn't joined us yet. Okay. Next question. This can be a little bit easier maybe, but how long does the trademark protection last in China? Okay. Okay. Well, everybody's pretty sure about the answer. Okay, I'll wait maybe a couple of more seconds. Okay, last question. Which of the following statements is true about customs in China? So customs in China check the import and exported products. Only trademarks can be registered with customs in China, or only the lawyer can proceed the records with the customs. So that's maybe a little bit more specific. Okay. Okay, I see that actually here only one person chose the last one. Okay, thank you very much. And we will redo the same questionnaire at the end and see if your answers maybe have changed. So now I will stop sharing and give the floor to Mr. Feng, who's our IP expert for today. And he will give a very comprehensive, let's say, overview of which are the intellectual property best practices in China. So I give the floor to you, Mr. Feng.
Thank you very much, Giacomo, and thank you for EU IP Helpdesk, as well as, more importantly, the Portuguese Chamber of Commerce and our Portuguese colleagues for giving, and European colleagues for giving us such a good opportunity to introducing IP protection in China. So I've been listening very carefully about our last presentations, which I think emphasize quite a few very important issues, such as to have a solid contracts when doing business in China, do due diligence with Chinese partners, as well as has a stamp on the official legal documents, to ask your Chinese partner to have a stamp with the legal documents. So all of these good points are very important in our daily business operation in China, and also our various work to supervise or to assist our clients do the good work. So from daily operations, we learn a lot from our clients who has been failed to do some of them and have some business miss some opportunity to have some lost in the second. So I think I also have learned a lot. So back to the point today, we're going to discuss IP protection and IP best practice in China. So I'm Charles Feng. I'm the head of director of the International Business Department of China of Tahota Beijing law firm and sitting partner of the firm. We're one of the largest law firms in China. We have more than 4,000 lawyers across China, with 27 branches across almost every single provinces of China, as well as we have overseas offices in Paris, in Washington, D.C., in Bangkok, in Sydney, and in Kathmandu. So we're almost have our offices in almost every continent. So we're working in different languages. Apart from Chinese, we're working in English, French, German, Portuguese, and other foreign languages. So we hope to have our opportunity to help our SMEs and also other Portuguese companies. In particular, when we learned that the Portuguese companies also feel difficult to find good partners, as Chinese lawyers, we also from time to time find it's difficulty to understand or to give good to find our business partner in Europe. So I think I will appreciate that the chamber give us such an opportunity to know each other and learn from each other. So our speech today will be in different parts. First of all, we'll discuss the basic scheme and knowledge about Chinese IP protection. The second, we'll give some emphasis on the trademark protection. And then we'll briefly discuss about trademark law revision and also the anti-unfair competition law revision. Because these two parts are very frequently used by foreign companies, including Portuguese companies, when their IP are infringed by Chinese competitors or other competitors. The patent protection will also be a part of the speech today, and also the proposed past revisions in patent. So what is IP? Probably, as you always know, IP will be included in different categories of subject matters, such as patent, design, trademark, copyrights. The different subject matter will represent different factors. For example, patents mostly protect the technology that's being used in your product. The designs will protect the look of your product. The trademarks is being used to distinguish your products from others, from your competitors. And copyrights mostly be used to protect the artwork and audiovisual creations used to publicize the products or publicize your contents. For example, you have a song or your articles. So different IP will have a different represent a different type of intellectual fruits. For example, patent will copyright and technology secrets. They represent the protection against intellectual fruits. They're per se valuable, which means that when you have a good source, you have some consideration of technology, you have a good arrangement of technology, or what we call the technical features, technical arrangement, or then they are perceived valuable. They're generated from intellectual creation from your mind or from your brain. And the use and transfer of such technology and knowledge will be through the contracts. And most of them will have a limited term and not renewable, because as IP law wants them to be in public domain and be well used, broadly used by the public, rather than be not dominated by the IP owner. By contrast, we'll have a commercial identifier, another type of IP, which includes trademark, trade name, trade dress, and domain name, such as. The characteristic of this kind of IP will be the value of this just with its owner. For example, you have trademark. It's very hard to say how much the value of a Coca-Cola brand, but if you need to look at a brand, look at a company, the Coca-Cola, the production company, how much the value of that company, then it reflects in the brand, in the trademark. And trade name, the trade dress also share the same methods of calculation. And domain name is well used in e-commerce and e-business. So the same character of this four types of IP will be the value is with the owner and they generated from the increase of goodwill of the owner. They're relevant to the commercial order and also no limited term and renewable. For example, if the trademark, as Glamio just said, every single trademark when it's getting registered, it will be protected for 10 years from date of the registration, but it's renewable. So theoretically, every single trademark can be protected forever. There's no time limits for the protection as long as you renew them on time. And you didn't lose them from any legal procedure. For example, every trademark that has not been used by 3 consecutive years, then you will run the risk of being canceled according to the cancellation filing by other party. So categorical IP, as just generally can be divided into commercial identifier and intellectual proofs. So trademark, trade name, trade dress, domain name, there's they can jointly be called a commercial identifier. Italian copyright treated more reflect the mankind, the creation of mankind, creation of your mind, and they mostly can be commonly called intellectual fruits. And how can get a trademark? As Giacomo just mentioned, in China, most important step of you to take is about application. So what can be a trademark? For example, this Danfoss is Denmark brand owner. Denmark trademark is for pump. The BMW is German. Automobile Schneider is a French electronic brand. So if it's a word or a design, then they can be a trademark. But also how, like this, Coca-Cola, this a bottle of Coca-Cola or yogurt, the bottle of yogurt or Nestle, the bottle of Nestle, all of this also can be trademark actually, as long as they are has been long been used and can be identified as an identifier of manufacturer and identifier of brand, then they also can be treated, can be protected as a trademark. So in China, the major problem is like this. The trademark Article 30, it provides that any trademark applied for registration according to the law, should not be identified with or similar to the trademark of another person that has been registered with respect to the same or similar goods. Article 31 provides that when 2 or more applicants apply for for the same or similar trademark with regard to the similar or same with regard to similar or same goods, then the preliminary approval will be given to the mark who filed first. This is what we call the first to file principle. Therefore, in China, until today, this principle is still being effective. So any single trademark, if you want to be registered, then you mostly need to file the application. And if some others has filed the trademark before you make the filing in China, then they will very likely to be granted a trademark registration than you. So you need to go through the other approach, such as trademark invalidation or trademark opposition against those prior marks before you get your own mark be registered. So in China, in most occasions, to file the application of the trademark as soon as possible will be a wise and a cost-effective approach for your brand to be protected. So the China, as you can see, this is from 2013 to 2017. All the trademark filings has been increased very fast, and this also gave a lot of problems to Chinese trademark administrations as well as companies, because too many trademark filing, and there's a lot of time for trademark examinations. And also, in 2010 offices, including Europe, even China, you can see that China has been almost doubled or 3 times of that of the US, or 3 or 4 times of that of the EU. So this is the number of Chinese trademark application is surprisingly high, surprisingly large. So this also gave a huge challenge to many European brand owners, or in particular SMEs who has their own brand being used or being registered in Europe for a long time, but not be registered in China. And when they came to China, to find a lot of difficulty to register them. So also we found a lot of what we call piracy, because a lot of them, they get to know some brand in Europe, and then they came to file the trademark in China without notification to the European brand owners. So all of this, this has been a problem, and this gave a lot of problem to both the brand owners and the Chinese authorities. So what the Chinese model said, the PRC, People Respect China, can be another meeting of priority country for filing. So in most occasions, the earlier filing will still have a good will be sound or cost-effective solution for you. Even sometimes the European brand owner have no local distribution yet, but for the defensive purpose, you are also recommended to file your trademark application in due course. And also, this has another function to avoid infringing others, because if you do not have you registered in China, then it's very possible for someone else already register the similar or identical mark in China already. Then when you have your product being imported or exported to China, then there's a possibility that the brand owner in China will sue you. They had their own trademark to be their legal basis to sue your products in China. And then another important issue will be preemptive registration. As I just mentioned, the Chinese trademark law provides first to file doctrine. Then for the brand who has filed, for the company who filed the trademark earlier, we're elected to have the trademark registration. And then when they have the trademark registration, the European companies come to China, they feel the trademarks being registered, and then sometimes they come to you for either for money or for the forced marriages or forced collaboration. So this will be the issues for some European companies, in particular for SMEs who have limited resources. Sometimes they feel this not affordable, and then what they have to do is to just change their trademark, which is not good for their global brand strategy as a whole. And then what can be registered? According to Article 8 of Trademark Law, any sign that distinguishes goods or services from others can be registered. As just mentioned, a word, a device, just a set of picture, or drawing, or letter, number, or three-dimensional sign, color combination, sound combination of thereof can be registered. So basically, any visible sign can be registered trademark, plus any audible sound mark can be registerable. So in general, any perceivable sign can be registered of trademark. This is a Louboutin. As you know, Louboutin is a famous French high heel shoe brand, and they have their solo color being used for their fixed position as a heel. And then this has been fighted up to the Supreme People's Court China, and they win this case at their trademark battle, law battle in China. So even for this kind of color mark and fixed position can be registered in general as a trademark in China, or at least this can be protected under the trademark law. The second, the most required will be distinctiveness. The Article 9 provides that any signs that has distinctive characteristic for identification and have no conflicts with other legitimate rights can be registered. So on the opposite side, the signs cannot be registered will be included the marks that only bear the generic name, devices, and model numbers of the goods. The secondly, the marks that simply indicate the quality, main raw material, function, use, weight, quantity, or other features. So all of this should be excluded from the subject matter as a trademark, because there either be what we call the generic term, generally excluded, similar to the European law. And secondly, will be their descriptive terms or descriptive signs. They're not registerable because they'll be misunderstood to be a description of any characteristic of that good rather than identifier of trademark. However, for the signs who have been long used and have acquired distinctiveness through the use and they're readily distinguishable, still can have their distinctiveness. As I just mentioned, you can see the the heel, the red bottom of the heel, in general, it cannot be registered as you. It's just part of products. But for the laboratory, has proved with the court that this shoes has been used for many long time. It can be identified by Chinese consumers as a trademark rather than simply just a part of the products. Still, it can be registered. So trademarkability is also always interesting and disputable issues. The drug voice has a three-dimensional sign be registered as trademark, and Intel has the dun 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 the sound and can be registered trademark. The John Deere has its colors combination of green and yellow be registered as a trademark. Zippo has its shape of the lighter as trademark, and all of this a French perfume bottle and the Coca-Cola bottle is registered. Can be registered. Another requirement is non-functionalities. If the sign or the three-dimensional sign, they are actually the shape of the inherent nature of the goods, or is it only dictated by the chief technical aspects, or only to give the goods substantial value, they're not registerable. There's also the similar to the European laws. So all of this non-functionality or non-distinctness are the hurdles that trademark fighters need to overcome for the trademark registration. But in most occasions, when it comes to the letter or a device, such as sign, those are very easily or mostly can be registered as a trademark without any problem. So when you come to how to register the procedurally, you got to know that in China, we have the application classes. The classes was called the needs classification, which is issued by WIPO, and the CCILC, the Chinese authority, has made some slight amendments against needs classification when it comes to some special goods that are relevant to Chinese culture or relevant to Chinese business. But in most of them actually the same to the needs classification. Because it's easy for you to make application in accordance with this classification. And according to this classification, we have 45 classes of goods or services. And trademark office, as I just mentioned, has made this slight amendment and is issued its own classification list. The class 35 is very special because it is what we call the promotion for others. So this is provide a system of operation management of commercial enterprises or a system of business activity or administration-based functions. This is a kind of classification very special and sometimes be refused to registration, but some Chinese good milestone precedent prove that it still can be registered when it comes to in special for supermarket services, for the wholesale services, it can be used for registration in class 35. So procedurally, let's go through this chart. You can see from the very beginning of the application, and then through the preliminary examination. In China, it mostly costs 9 to 12 months. Your application will be approved preliminarily, and it will be published from what we call the Gazette. It will get the preliminary approval. Then it will enter a stage of 3 months. It's called opposition term or opposition period. So from through that 3 months, any person in China can file the opposition against your application. And if there's no filing of opposition or the opposition through examination is rejected, and then your trademark will be registered. So again, you'll come to the Gazette, what do we call it? The registration Gazette. So from the date the issuer of registration Gazette, then your trademark is a registered mark that can be protected under trademark law of China as a registered trademark. And still, if you fail in the opposition, the party of the filer or the party of being opposed can file an appeal with TRAB, the upper side of TMO, which is like a supervision body, and who will give the final decision of that. And if the trademark is registered, or for another trademark who has been registered in China for a long period of time, still you have a remedy as invalidation For example, you came through a trademark that is identical to your brand in China without the knowledge of them who registered you have never been aware of them, but you feel their trademark is very close to yours, then you're authorized to file validation against it. Mostly from the within the 5 years since the date of the registration. However, if your trademark is a well-known trademark, then you are allowed to file the validation even after the 5 years. When you have the validation or you have the final decision from here, then according to the TRIPS of WTR, any administrative decision should be subject to the judicial examination. So Beijing IP Court will be the one who are supervising the CNIPA decisions. So you're allowed to file the administrative litigation against any CNIPA decisions, mostly within 30 days since the date of the issuance of that CNIPA decision. And then the Beijing IP Court will have a court hearing. The court hearing will have 3 judges to constitute a panel to try your case. And then after the trial, you will have the court decision, what we call the first instance. And China has a system, a judicial system of 2 instances. Therefore, if you are unsatisfied with the decision of Beijing IP Court, you still have the final chance to challenge it with the Beijing High Court, which will be the final decision. If you still are unsatisfied, you want to challenge them, you can still what we call the retrial with the Supreme. However, that is now the third. It's not the third instance, because in most occasions, this case will not be retried by Supreme People's Court of China. Only if the Supreme People's Court find your case, the decision of this extremely wrongful and very much worth challenge, very much worth retrial, and they will take the case and retry the case, and there's possibility to correct the wrong decision made by the Beijing High Court. But in general, the ratio of this is very limited, let's say about 10% or less than 10%. So therefore, if you go to do business in China and do clearance research to check the previous marks in China who has been registered in China before you file the application and before you use the trademark in China is very important. And so the Chinese database is available from the internet. The trademark office has a free online database. It's available for everybody to try. As a lawyer, we do have our professional database. It's more easily updated and have more information than this TMO public database. But you can use them for the preliminary check or engage us as a lawyer to do the more professional check. So defensive registration, full coverage defensive registration. So application for sub-brands. So most brands will have their primary brands, but for sub-brands, because they're still be used in your business in China, and it's also recommended to register, apply them for registration as soon as possible. And broader specific goods and services have more broader application will be beneficial in general, because otherwise someone else maybe apply for registration in some goods or services very close to you, and you will feel difficulty when you want to either use your brand in those fields, or you have your products in this brand and be challenged by other trademark owners. And Chinese translation of your trademark is very important, because the Chinese consumers, although some of them understand the Chinese English, but most of them still may not be 100% understand English. So you have your Chinese trademark being translated to China before you have your brand being used in China will be good and a very wise decision. So make translation with your own business person, with your Chinese lawyer, will be easy for you to develop your Chinese market. A defense application, as I just mentioned, to make the defense application, if you do not use them, will be good for you to keep your scope of the business, or at least to defend from others preemptive registrations. Application to block potential exportation. Sometimes you have an application be made in China and registered in China. Then, as Giacomo just mentioned, the Chinese custom will not just administrate the products come into China, but also can intervene the products or get out from China. So if you have your registration, trademark registration, not just from CNIPA, the trademark authority, but also registers them with the general custom of administration, general administration of custom of China, then they will be possible for them to stop the counterfeits or stop infringing products that manufactured in China and exporting from China to Europe, other jurisdictions, such as exporting to Europe. So this is a very useful tool for you to register them. This is an example. So someone has their Chinese Mr. Muscle, the brand, and they have their English, the Chinese translation, and they have the combination of English translation. So whether you want to register them as a single word, or you want to have their being combined with a combination mark, let's say that it will be different approach and different functions. So if you have an individual trademark, such as Latino, English, Chinese, or device, and then the advantage of them, the easy, the less obstacles and more easy for registration, and more flexible to use if we use this or use it in combination. This is your choices. Advantages in fighting against individual trademarks. So combination trademark, for example, the combination of Mr. Muscle and its translation will also has their own advantages. For example, the disadvantages have more obstacles and have maybe more difficult to register, but it has advantages against fighting other combination marks or fighting against individual marks. So because any other be close to either the English part or the Chinese mark will be found as similar to your registration, then they should be either be excluded from the registration or be excluded from the use. So it's easier for you to protect your brand as a whole. So if you have some trademarks that you want to apply, but you found prior use of their trademarks, then the most important to remove the potential obstacles will have different approach. For example, we'll suggest our clients to do some investigations on prior marks to evaluate the chance of removing them by non-use cancellation. As I just mentioned, the Chinese trademark law provides the approach, the remedy for non-use cancellations for any trademark that has not been used for 3 consecutive years within China, then they can be challenged by non-use cancellation. If you have find some others, they either preemptively register your trademark, or they occasionally register your trademark, or they occasionally register some trademark similar to you and block your registrations, then probably you can do some investigation from internet and from on-site and decide whether they're vulnerable for non-use cancellation. Then if you find they're not used for 3 years, then you can easily to tackle them by the non-use cancellation. And sometimes they have been used and not easy for cancellation, then you can do some negotiation with them, because someone actually have the marks they're not being used, and or the trademark, the value of the trademark very limited. We have been helping some brand owner, foreign brand owners to purchase that trademark by assignment. So in China, any trademark is assignable, so you can establish assignment agreement with trademark registrant, and to get trademark be assigned to you, and then you'll be the new trademark owner and free to use it. So in general, English marks very useful or may automatically be available for most European companies, but Chinese language mark, as we just mentioned, is a must in most occasions. And you want to select early, and you want to search and find. And logos also be useful and important. Labels, some labels are being used in your product designs, and they're not registered, but you want to register also as well as must use. So trademark search every 6 to 12 months, do some search, some from some others, but the registered trademark close to you to file opposition against them, not to do them, no less than go too far to register, but to oppose them during the 3 months of opposition period will be a good way, cost effectively protect the brand. And buy some mark from Paris is sometimes is a cost efficient way, but not in every case, but just in some cases.
I'm sorry to interrupt here. Charles,
Okay.
we can
Time
come
lapse.
to customs and trade secrets.
Okay.
Because due to
Okay,
time
sure.
constraints, we
Okay,
are
we'll go
running a
to
little bit
secrets.
late.
Yeah. So trade secret, as you understand, is under the protection of anti-unfair competition law of China. We know, in particular, the technical companies will address trade secret very importantly. As you understand, the trade secret is in general, it can be divided in two parts. One is tech secrets. The second will be business secrets. The tech secrets would be mostly referring to such as formula, technical design, technical features, or some other technical relevant factors that will be important for a company to get their competition power or have their competition benefits, but they are not be registered as a patent or other industrial properties. So according to the anti-unfair competition law of China, the trade secrets will be need to satisfy three standards. The first will be secrecy, which means that any trade secret cannot be known to the public. This known will be globally if your technical solutions has been made published by an article or by any advertisement of you or by any trade fairs, then they will likely to be lost their secrecy and not be protectable as a trade secret. The second will be the economic benefits. It's very easy because most technical trade secret, such as technical secret or businesses, they have their own economic benefits. The last will be confidential measures, which means that any IP owner of trade secret, they need to take reasonable measure to protect the trade secrets. If you have your trade secret, but you have never made protection against them, such as password. If a document you want to keep them with a password, if you have your internet or intranet, you will be restricted to be accessible to just some of your stuff, not every single body of your company, or not to mention the public. So such as measures will be important, will be need to be proved before you ask for the remedy for protection of trade secret. Unfair competition law. So it's Article 9 provides that should not commit the following infringement. The first one will be illegal obtain or illegal acquirement of a trade secret, commercial secret, trade secrets, such as you cannot get the trade secret from theft, bribery, fraud, coercion, hacking, or other improper means. And secondly, it prohibits any use of such secret by which has been acquired through the illegal way, as just mentioned. So if you have been obtained a trade secret from theft or from hacking, and then you disclose them or use them, allow the others use them, then still you'll be found as infringement or misappropriation of the trade secret. The third will be violating the confidential obligation or rightfulness requirements. It means that someone acquired trade secret from legal way, such as a contractor, they have your trade secret, but if they use it in different way that are exceeding the scope of contract, then they can be found as a misappropriation infringement as well. The last instinct induces as otherwise. This is a purely assistant infringement or conspiracy or contributory infringement. So last, I will discuss a little bit more protection of trade dress and trade name. As you understand, you have a company name or your design is very special, and then they're very easily to be copied or infringed by others. So under the Article 6, to protect any signs with an identical similar of name, packaging, decoration, or the use of information made of enterprise. You have a company name, and then you have used it in China for a long time. And then even they're not registered, they can be protectable under the Unfair Competition Law of China. The third will be domain name. From the business perspective, you have the domain name be registered in Europe, but then used accessible in China. And then you got to know that's still protectable under unfair competition of China. And website name, web pages are also protectable. That will be other ways. There will be a supplemental way. So trade secrets, when you want to protect them, it's got to feel satisfy a few threshold. They got to be famous. The trade secrets are going to be famous and distinctiveness and non-functionality and lack of confusion will be proved. So all of these are very similar. So one case we have the L'Oreal against the infringer. They copied their designs, trade secrets, and copied their trademark. And they also use the trade name. And Hangzhou L'Oreal will help them find it in Hangzhou Medical and won the case. And also the filed the 50,000 RMB as a compensation. The highest under the trademark law that in that period. And this is from Zippo letter, and Zippo, the American letter manufacturer, there is the domain name, and they use the trademark indicating the name of the store, and also the domain name. We filed the civil lawsuit, and the UDRP parties win both the domain name, the trademark, and also the photograph is a copyrightable subject matter. This is filed from the European company who are providing the declaration, and it's also protected under. To take away from our presentation today, make application registration as soon as possible for both CNIPA, and if you have problem in the custom cross-border business, or you have infringement from cross-border, where you're advised to register with the Chinese customs or with the general inspection of customers as soon as possible. Engage lawyers and local salesperson in China to monitor the physical market, cyber markets, and trademark gazette. So you got to know your Chinese market as soon as possible and as broad as possible to protect your market. And know your competitors, monitor them. So some European companies, they have their competitors from China. They know they used to, for example, used to collaborate and they broke down in the middle of them. And then they come to be their enemies or competitors. So these people need to be monitored. And find a reasonable court of sue. This is what we call forum shopping. And you have business infringer in China, they have the manufacturers and their salesperson or distributor in different cities of China. You got to find the right city to sue. And sometimes it's come to us as your Chinese law advice, a good place, a good forum for you to file the litigation. And find experienced lawyer, very important, 10 years or more, would say in China, not the lawyer, every single lawyer will be able to do the IP case. You got to find experienced IP lawyers like us to help you when you have IP cases, very special field. And so some of the lawyers can do some other contract work, but not necessarily to know the IP laws and the fun and the battle of how to fight the IP battle very well. Pay attention to friendly IP campaigns and pay attention to change of new trend IP policies. For example, now very recently the Chinese State Council and Chinese President are appealing for foreign business in China be good time for you to fight against your Chinese counterfeit, Chinese infringers, and to have your IP be protected as much as possible. Thank you for my presentation today. Thank
you very much, Mr. Feng. Indeed, the topic is very technical, so thank you very much for given us the overview. So at this stage, I invite you to think about questions to our speakers, to Mr. Mendia Ferreira, Mr. Petino from the EU SME Centre, and Mr. Feng. So we can open a very 5 minutes Q&A since we are running a little bit late. And while you think about your questions, you can also take your device and go to menti.com. I will do once again the quiz and see if your answers are different from before. So here is the new quiz. You can use the code here, and I'll wait for your answers. So we can wait a little bit. If somebody wants to give it a try. And maybe in the meantime, you can also think about maybe some more detailed questions that you have. Okay, we have the first brave person. Of course, the quiz is anonymous, so we don't collect your data. So feel free to join us. Okay. Maybe we can go to the next question too. Okay, there were two people. I actually encourage you to give it a little bit of a try, so we can assess a little bit the activities. So that's very important. Okay, two people, three people, they voted for 10 years. That was the most popular answer. Maybe Charles, you want to elaborate a little bit? Yeah, I skipped the answer before, but you can give a little bit of context and say if it's right or wrong.
I think Giacomo, I saw a question from the chat. First of all, how long does the trademark protection last in China? I agree with you that the trademark, as I just mentioned from my presentation, is in theoretically is IP that can protect it forever as long as there's no legal reason for the invalidation or cancellation, and the trademarks renew timely every 10 years.
Yeah,
so theoretically can protect forever. But for one term, it will be 10 years, as you just mentioned. So may I ask one question from the chat?
Well, we can collect them later. We can just skip to the next one. So for those who are connected on Menti, which of the following statements is true about customs in China? So customs in China check the imported and exported products. Only trademarks can be registered with customs in China. Only the lawyer can proceed the records with the customs. So maybe Charles, you can.
I think most of the answer was give the right answer. The first answer is correct. Customs in China can be, in terms of IP, the Chinese customers are checking, inspecting both the importation and exportation, because China has been a world manufacturer for many years, and not just the Chinese market per se are as a destiny of violations, but also Chinese products are being many infringing products being exported to other jurisdictions. Therefore, the Chinese customers, according to the IP protection regulation of the General Administration of Customs, the Chinese custom will check both the importation and the exportation of goods from the IP perspective. And secondly, here is I think the answer is also correct. Not just about trademark being registered with customs, but also for other IPs, such as patent, such as design patents, such as copyrights, they also can be registered. However, in most cases, from the perspective of protection, mostly protected IP, actually the trademarks, what do we call the proactive protection? It means that when the products go through the Chinese customs, then the customs officials will initially check against these products. But for a design patent or for technical patent or for this kind of technical issues, the Chinese officials, custom officials, will have more difficulty to check them, and they will more like what do we call the reactive protection, which means that the IP owners will give their information to the customer to say this column or these boxes of product are infringing. And they initially tell the customer to specify the goods and give their guarantees to the customer, and then the seizure will happen.
Great. So to sum up, I think everybody did a good job. So the answers were just for reference. when does the trademark protection take effect in China? The right answer is once the trademark is registered in China. How long does the trademark protection last in China? 10 years. And the last one you elaborated very well. So we can collect the questions from the audience. I invite you to write any type of doubt question that you have in these minutes that we have left for our speakers. So you actually have elaborated a lot about customs. So here we have an answer. Does this include design patents as well? Speaking of when registering IP with customs, the focus should be on trademarks and patents. And are copyright registrations useful to register with customs as well? And another question would be, what about the average cost for registering a trademark in China? So maybe you can answer this question.
Yes. I think the cost in China, it generally have two type of cost. One type is official cost. Official cost for filing a trademark application is very low. It's about 300 RMB. And for the attorney fees, it will be depending on the different lawyers. As us lawyers, we charge very cheap. We just have a few hundred RMB for represent a client to register the trademark.
Okay, great. So I think we're running a little bit late. So if somebody has other questions, this is the moment. Otherwise, I really encourage you to follow our projects, both the EU SME Centre and the China IP SME Helpdesk, as well as getting in touch with the Portugal-China Chamber of Commerce and the Chamber of Commerce and Industry and the AICEP Global Portugal. So I think that there are no questions from the, one more.
Yes, there are some questions.
Yeah, last one. Is it true that for opening a business in China, we should have a local shareholder? Maybe Alessio or Bernardo or Mario, you want to answer it?
Yeah, depends. China has a negative list for foreign investment if you operate in a sector which is included in this list. There might be requirements like this, like to have a joint venture, which could be with the equity cap set at 49, 50%. So depends, but there are not that many sectors in this list. For all the other sectors, no, you don't need to have a local shareholder. You can just be a wholly foreign-owned company. Could be natural person, could be a company. You don't have to. Well, it depends on the sector, but generally you don't have to. Now, is it the best option not to have one? That's up to you, I think. But it has advantages. It has disadvantages, of course. But you're not required to have it.
Okay, great. I think that maybe Mario wanted to add something.
No, the first question should be to Charles.
Okay, great.
What about the average cost?
Sorry, maybe we didn't hear you?
I mean, maybe there's another question before that one about the cost.
No, we already answered.
The cost as well.
Yeah. Charles answered the question already. Okay, great. So thank you very much for today. I think we covered all the topics, best practices, both for business and IP. And one more time, follow us, the EU SME Centre and the China IP SME Helpdesk, as well as especially if you're a Portuguese company, of course, the Portugal-China Chamber of Commerce and Industry and AICEP Portugal. So thank you very much for today and have a nice holidays ahead.
Thank you. Merry Christmas.
Thank you. Look
Thank
forward
you.
to working
Bye-bye.
with you. Thank you.
Bye.
Bye-bye.
Thank you.
Great to know you.
Good to know you too.